Okay, I have 6 o'clock, so welcome everyone, and we'll let folks in as they arrive. I know we have quite a few other folks registered for this informative evening. My name is Sherry Brown. I'm director of the Massillon Public Library. We also have on this call Miranda Greathouse from the library staff, who's our host, our Zoom hostess for the evening. And then I'll introduce you to the panel in just 1 minute. Just to cover a few of the background of why we're doing this. I spent 25 years at the reference desk, and I'll tell you, just continually, we had a lot of questions from landlords and tenants on, what the law, what the legal issues were. We've always had books like Tenant's Legal Guide, Landlord's Legal Guide. We more recently, Community Legal Aid gave us these Your Rights as a Renter that we have at the reference desk in the reference room that we're passing out to people, which is a great resource. We have databases you can use with your library card, such as Thompson Gale legal forms. So if you're a landlord and need to draw up some kind of rent agreement, we have access to all of that material with your library card. But I've always said that our best resource are the people that we know. And we're just really blessed in our community to have people willing to share their expertise with you. And Andrea Skaza came to our Rotary meeting not too long ago, and we just started talking. I said, what I've always really wanted to do is host some kind of program for landlords and tenants. And she said, let's make it happen. And I said, who else shall we call? And that are these people that are joining us this evening to share. I thought I would just have them introduce themselves. So I'm just going to go in alphabetical order and call on you if that's okay. Tell us who you are and what your organization is, and basically who you serve and what kind of help you can give people. So let's start with Beverly Lewis.
All right. Good afternoon. I would say good evening, everyone, since it's 6 o'clock. I am Beverly Lewis. I am the housing director for the city of Massillon and the fair housing coordinator. I work indeed for the city under the mayor's guidance and all of that. And so I am very glad to be here. Thank you, Sherry, for the invitation. And it gives us a grand opportunity to share a little bit more information in a broader aspect. Thank you.
Thank you, Beverly. And let's go to John Pettit.
Hi, everybody. My name is John Pettit. I'm a managing attorney at Community Legal Aid. And Legal Aid, we have an office in Stark County, and we cover 7 other counties in the region here. And we provide free legal services to lower income, marginalized, and elderly people in civil areas of the law, and that includes evictions. And we certainly deal with a lot of people facing evictions, and we work with representing tenants primarily. And then we also have a neighborhood law project that we've been starting where we're helping tenants who are in the process of forming tenant unions to help them organize and empower themselves.
Interesting. Thank you. Andrea?
My name is Andrea Scassa. I'm one of the magistrates at the Massillon Municipal Court. So I am the person that you see, unfortunately, if you are in a situation where you're having trouble paying rent, or if there's other circumstances going on in which the landlord-tenant relationship is seeking to be terminated by the landlord. So like I said, unfortunately, I'm one of the 2 magistrates that could potentially be handling your cases, but we do try, and especially in light of the pandemic conditions we've been under, working with the next presenter who will introduce herself, and the few cases, because they are stretched so thin that legal aid does represent tenants in our court. I always appreciate when tenants do have legal counsel. So thank you, John, for all the work that legal aid does. We appreciate that.
Thank you.
And Amanda.
Hi, I'm Amanda Stewart. I am the Amanda Stewart Williams. I am the Community Service Block Grant Director for Stark County Community Action Agency. And currently we are at the forefront of working with families who are facing eviction or utility shutoffs. So we have many different pots of money that can assist families with those type of things. In normal times, we also provide assistance such as workforce development, food vouchers, just different community service projects. But as of since COVID-19, we're really spearheaded in housing and all things related.
Thank you so much and welcome again to all of you. Thank you. Let's just jump into what we think is kind of a timely topic, and that's the moratorium on evictions, so that we realize you're probably seeing more of this than you have in a long time because of the pandemic. Would anybody like to address how the increase is hitting the courts? Maybe Andrea, maybe how each of your agencies are dealing with this influx of evictions.
Sure. So I actually took the bench February of 2020. So just sort of right before everything hit. And as I was taking over the eviction docket from now Judge Fichter, he was Magistrate Fichter then, in my training, on the job training, there were some days where eviction court would have 20 evictions, 25 evictions, and it was, just boom, 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 one after another. So then when the pandemic hit, as everyone has experienced, evictions stopped, and that was essentially a lot had to do with what we were doing in the courts and allowing people in. And so there was that movement. But then prior to the moratorium, there was the CARES Act that was put into place. A little bit different type of relief than what the CDC moratorium provided. But if you saw headlines, not only across the state of Ohio, but across the country, I mean, some courts were just completely not hearing evictions whatsoever. Us at the court, at the Massa Municipal Court, we never actually stopped accepting eviction filings, I will say. But as far as hearings, those did get set out. And a lot of that had to do with just the health orders that were put into place in conjunction with the CARES Act. So yes, our numbers for evictions were way down. And then after the CARES Act expired, it seems so long ago, but I think that was the end of July. Correct me if I'm wrong, John, but that's what I think the CARES Act expired. And then the CDC moratorium, that order was put into place. I think it was like September 3rd of 2020. We saw a little bit of increase in eviction filings. Now, with every expiration of the moratorium that came and then passed, and then now there is no more moratorium, and that was more or less due to a decision by the U.S. Supreme Court that was handed down a couple weeks ago. But whenever those deadlines came, we would see a little bit of an uptick in eviction filings. Now, that could be landlords anticipating the expiration of the moratorium. But at this juncture, I wouldn't say that the court has seen the huge influx of cases that you might read about in some of the larger metropolitan areas, Cleveland, Franklin County, maybe down in the Cincinnati area. I know there's been sort of that fear that when the moratorium ended, that there was just going to be an onslaught of eviction cases. And thankfully, I would say, and I don't know if that's attributed to landlords and tenants maybe working things out, maybe the relief funds really flowing into our county, that it seems like maybe other communities aren't tapping into or able to tap into as readily. But at least for us, now I can't speak for Canton or Alliance, the rest of the county, but at least over in Massillon, it doesn't seem like we have been hit with this onslaught. Now, we usually have our evictions just Wednesday afternoons. And I was saying before the meeting, I think I have 8 tomorrow afternoon. And I've sort of looked over the next couple of weeks. So as I say this, probably next month, I will have again 25. I'm probably jinxing it, but that's at least what we've seen thus far with everything.
Interesting. John, I've seen you shaking your head. Are you seeing more questions than you've been getting?
Yeah, we've been really swamped with a lot of requests for service. As Magistrate Scazza said, that many of the courts, including Massillon, have been very good with working within the constraints of the law and abiding by moratoriums. But our challenge has been, we get a lot of calls. We deal with a lot of landlords to talk about, is the moratorium in effect or isn't it? And there was a lot of back and forth with that. And so that created a lot of legal work. We've had some cases going into court where some of our role sometimes we feel is to educate the court as to tenants' rights based on the individual tenants we represent. And so we've had a number of those cases, but I think also we've worked more so than ever with the eviction rental services providers like Ms. Stewart's organization, Community Action, the other organizations out there to make sure that rental assistance is available. And that has helped. And we cover 8 counties, and some counties have been more active with the rental assistance. And in those counties, evictions haven't been as vast as in other places where that assistance isn't there. But certainly there's a growing uptick that we see coming in. And it's been difficult, I think, certainly for landlords and not getting the money, and that's real important to get that rental assistance out there. And then tenants sometimes have misunderstandings of what a moratorium means. That they, of course, we always advise them that their responsibility is to pay their rent, and some of them haven't done so. And certainly, if they're allowed to get assistance, that's helpful, but other ones don't qualify, and when they don't pay their rent, eventually they're going to be evicted.
And Amanda, that's a great segue into what help is available. What is the assistance that people can apply for, and how's it distributed? Can you explain about the program?
Well, currently we have several different pots of money that provide different assistance, and that's a great thing. I think there's a misnomer out here that we're not spending money, but I think the bigger picture is that all agencies, whether it was our agency or Job and Family Services, have money, and they're all coming from different portions. So we may have spent 11% of this pot, but we may have spent 80% of another pot, because the resources are so vast and far. She's Magistrate, I want to say Andrea, Magistrate Andrea stated earlier that, it was, one of the things that she said was that she had CARES dollars. So we also had CARES funding. So when we started when the pandemic started, we were able to utilize CARES funds to help people with rental assistance and stuff before the moratorium was in. We also had our usual, funding that we also always applied to emergency assistance. But since then, we've had, city dollars from the city of Massillon. We've had city of Canton dollars. We've had, state dollars and stuff. So the funding is so vast and various, and it's enough to help people with water, utilities, back rent and stuff. We can currently pay up to 12 months of rent. And if there's an extra 3 months in that we can provide stabilized housing. So every program might be a little bit different, and it's tailored to fit the needs of the families that are asking for it. But we're trying to be flexible with it. One of the things that we do is, if someone has been evicted, in order to help other landlords kind of say, okay, I'll look at this person and say, we'll help them. We may say, well, what's your deposit? And they say, well, if you give us 4 months of a deposit, then we will go ahead and consider, housing them, because they want to have something to hold on to in case they default again. So there's all these different ways that we're trying to layer this assistance to help the people that's needing it.
And is your agency the good starting place for people asking these questions or trying to find out what all their options are for assistance? Would you be the first call that they would make? What would you like?
Yes, I would love to say that I would say contact any and everyone that might be able to have assistance. But yes, we are usually the first call, one, because we have we have a built-in population that we've always served. We also provide, because we also have heat. So it's always been one of those things where let's stop and ask them, because we've always worked with this clientele. We've always worked with low income populations. So this hasn't changed. So we've always been able to meet them where they're at. So that's one of the first things that they do. And also, which is different than a lot of the different programs, is we can stabilize. Like I said, we can pay 3 months ahead. So a lot of times when they're delinquent and they're 6 months delinquent, and we can give them up to another 3 months to stabilize, that's the landlords and stuff are willing to accept that. And it helps the family to get back on their feet. If they don't have to worry about the rent this month, they can catch up on the car payment, they can catch up on the food, they can catch up on clothing and all those different things that or even medicines, for that they're dealing with. So this is a great stop for us right here.
Absolutely. You're like the clearinghouse, and great place to start. At the end of this call, I'll have everybody give your contact information again, so that everyone will know who's been speaking to them and how to get a hold of you. So that's wonderful. What remedies then exist for landlords if they have somebody like John was saying that's really, misunderstood what this whole moratorium is about, just hasn't been paying their rent? The landlords probably have a mortgage and utilities and upkeep of the building. And is there anything to help them? Is there any programs? Anybody want to jump in on that? Or
I could jump in, and I know that some of the moratoriums have existed also to prevent foreclosures, and those have been in place, especially persons who've had any kind of a loan, like an FHA loan that was subsidized by the government. They've been covered under that provision, keeping them from getting behind with the foreclosure. However, the rental assistance, really, a lot of the attorneys that I work with who represent landlords, we negotiate a lot of cases. They, will view this really as a landlord bailout too. A lot of money is out there. And so, we encourage them to work with their tenants to help them make sure they understand that the money is there. There's as Ms. Stewart indicated, I know Community Action's been really great with getting out the money. There's been some agencies that have struggled getting out the money, and a lot of money has come through Job and Family Services, and that had a lot of strings attached to it. And so it's been difficult, I think, for some people to access it, especially if there's not a direct COVID link for the money. But landlords that are in this situation, I would tell them the same thing that I tell tenants, communicate with each other. That's the first step. We always advise our tenants to keep the landlord informed of your situation, what your plans are, that you're going to try to get assistance, that, if your hours have been cut, when do you expect them to get back again, so that, landlords have an understanding of what's going on, so they, hopefully avoid that eviction when at all possible.
Yeah.
May I piggyback off of him really quickly? One of the other
Yes.
things is in our portal, the landlords are actually able to apply for the assistance for their tenants. So that's one of the starting points that we may have, is that if a landlord puts their contact information in, we can reach out to the tenant to assist them in filling out the application to get the assistance that they need. So that was different than in a lot of the different places, but there's a piece of that we can accept that. And the other big thing that we're seeing now is, especially in the city of Canton, they have decided to, their water bills are not going on the landlord's tax bill, because they haven't paid them in a couple of years and everything like that. And we're able to assist with the water bills, because obviously they're in the landlord's name. So that's helping to prevent some of those evictions that come around in Canton, or if the landlord is holding the water bill. So that's one of the things that has been a great assistance to them, to help to keep their taxes down, because that's where they're headed now.
Interesting. Thank you. Now here's a legal term I don't know, and that is second cause issues. But a question had come up about, is a tenant still responsible for back rent even after they're evicted? And maybe, John, that's one for you as well.
Sure. So, yeah, with any kind of contract, you're responsible for the terms under that contract. And so if you don't pay your rent, it is your responsibility to get that paid. And if you can get assistance for that, all the better. But eviction cases have two parts to them, and the first part is whether or not the landlord is granted possession of the property back, and that's our focus at Legal Aid. We focus on housing stability, and so we focus on those issues more than the financial end of it typically. Some landlords, they can choose to decide to go forward on the second part, that is any money owed or damages to the property. Some choose to do that, some choose not to, based on whether or not they think it's really, if they're able to collect that. But certainly from a legal standpoint, that is still their responsibility. And it's very important too with people who have a housing subsidy, if they're on Section 8 or have in public housing. It can be very detrimental if they get an eviction and they owe money. They can be banned from getting another Section 8 voucher or getting public housing for 3 years. And then even then, until they pay up that balance owed. And so it's very important not to ignore that because it can have detrimental consequences.
Interesting. Beverly, we haven't picked your brain here for a few minutes. You might get questions about from folks who have an eviction on their record, and then it prevents them from finding new housing. Is there any way that they can have that sealed, or how do you advise people that contact the housing department? Oops, you're muted.
Sorry. Yes, thank you. That's an interesting question. I've not had anyone really ask me that in regards to that particular kind of situation. An eviction, that's a hard one, really, when you think about it. And oftentimes, so I've had individuals who have been able to get into another place because the landlord does not do checks. They don't do the check to see if they have had evictions in the past and that kind of thing. So we do have that situation as well. To really answer as to the law, what would happen, I think I would have to roll that to someone else. Mm-hmm.
Maybe we'll piggyback off of what you just said, and I'm going to jump ahead a little bit and talk about landlords checking references and what is okay to check, what's legal, what's not, what are the reasons a landlord can say I'm not going to rent to you, and what things are they not. And this is definitely a fair housing kind of question if you want to.
Mm-hmm. Oh, absolutely. There are a lot of screens and things that landlords can do. And often I do find that they aren't doing those. They aren't doing the due diligence on that. Some do, and many do it very well, but there are many who do not. But it is very important that they would take time and do a screening in a way that is appropriate. And what I'm finding out is that whatever screening that's done by a landlord should be done for everyone equally. And sometimes there are some biases, some things that happen, preconceived ideas and notions about individuals that make landlords ask questions of one that they don't ask of the next one. And the easiest way really to stay out of difficulty is really to ask the same questions to everyone. And so then you don't have that happening. As you find in screen tenants, you're constantly learning new information about prospective renters. But as you go through applications, you might also be worried about whether or not you have a valid reason to deny one of them. Under the Fair Housing Act, there are a handful of laws protecting tenants from discrimination and being unfairly rejected for certain reasons, including familial status, sex and gender, disability, religion, color, race, and national origin. You cannot reject a potential tenant based on any of these protected classes. That said, there are still some cases in which you can decide not to rent to someone. Here are just a few of them. The tenant doesn't make enough income. So one thing, if you're doing your due diligence as a landlord, you're getting that application and putting all the information on there that you will need to maybe make a determination as to whether the potential tenant will be able to afford the rent for the next year or however long the lease agreement is for, or from month to month. The typical rule of thumb is that the tenant's income should be 3 times the price of rent. We recommend you review all of the tenant's information in their credit report or ask for proof of other savings or financial backing before making a decision. Another thing, a key thing that would be good for landlords to do, to find out if the tenant smokes. That can be one of the questions that's on the application as well. You can ask a tenant if they smoke during your initial conversation, during the property showing, or on your rental application. The sooner you find out, the better, so you can move forward with tenants who are a good fit for your property. Smoking is important to consider because smoke can create a lot of problems. It's a health hazard. And, to the one that's smoking, they might not think that's a problem, but to others who could breathe that smoke coming through the registers or whatever, it could be a problem to other tenants. It's also a fire hazard, and it can cause interior odor problems that are hard to get rid of. If you don't want a tenant who smokes in your property, you are legally allowed to deny them for this reason. Another would be the tenant has a pet. If you don't allow pets in your rental property, then you can deny a tenant who wants to rent with a pet. Okay? It's common for landlords to have rules about pets. For instance, some landlords only allow pets that are certain type, certain size, or certain breed. It's important to find those things out. Some landlords allow pets, but also charge pet rent or pet deposit on top of the rent. So whatever rule you choose, you are allowed to deny a tenant if they don't match your pet requirements. All right, and there are some exceptions to that because state laws differ in different places. So you need to find out what your state laws say in regards to that as well. And certainly when you get into service animals or anything like that, it is important for you to know the rules and the regs around that. Okay, there are just so many things that you can deny really a tenancy for an individual seeking a place to live. If the income isn't verified, if the tenant has been convicted of a crime, you can deny them. There are certain things that you have to look at and you have to consider in that, but you still can do it. The tenant does not have a rental history, so you have nothing to go on. Perhaps that person, though, just came from living with their parents, or they were in a dorm situation. So there are many things that you have to consider. So those are some of the reasons, and that's certainly not all of them, that you can deny a person tenancy. And the other ones certainly are those protected classes. You kind of want to be very mindful of what you do in regards to that, to them as well.
It does sound like consistency is the important thing. So if you make a determination in one case, it has to be the same criteria that you would apply for another renter, it sounds like. Thank you. That's
Pretty much.
it's a very thorough response. I don't want to forget to ask if anybody else had anything to say about the sealing a record of an eviction. Is there anything that somebody can protect themselves for down the road to not have that show up on the record, or is that just going to follow them?
Yeah, I can touch on that one, and I don't know if Magistrate Scanzo wants to jump in too, but unfortunately, our legislature doesn't have a specified way to seal an eviction record like it is for a criminal record. However, we found that that is very problematic for people finding housing, and especially those that were evicted during COVID. If they had, we found our client base really expanded. We were dealing with a lot of people that had never been evicted before, but unfortunately their hours got cut, especially those in the service industry. And so they found themselves having an eviction filed. And often those evictions got dismissed or resolved because the rent was paid through rental assistance or they started working again. But that eviction still remains on their record, and even though it wasn't even granted, and then if they go to move or they have to move, their lease is up, it becomes very difficult for them to find a place. And so we have had some cases where we have filed in court. There is a mechanism through the Supreme Court rule to allow certain things to be sealed. And so we have had clients who we've had their evictions sealed for good reason. But it's my understanding the Supreme Court is looking at that. They're looking at developing standardized forms and giving courts more guidance on the ability to seal eviction records, because we found that's really needed. Of course, some cases it's just not appropriate to seal it. Landlords should be entitled to see if somebody is a bad tenant and has a bad rental history. They can make their own decision. But there are many other cases, especially in cases where the eviction got dismissed, where people should have the opportunity to have that sealed so it's not used against them.
Andrea, anything?
And Attorney Pettit is correct in that there isn't a similar mechanism within the law or within the revised code for eviction, specifically eviction, or really even that references eviction or ceilings for, civil type of cases. For the criminal world, it's laid out in statute. It's sort of confusing with the way they've changed the laws recently, but it's at least laid out in statute for criminal type of cases. And we just don't have that for civil cases, and especially with evictions. Now, I can say that the Madison Municipal Court rarely has granted sealings of eviction cases. In side note, I did used to work in Canton Municipal Court as well, and I can say it was rarely done over there as well. Now with the pandemic, it's sort of a whole new situation. And I can say that the few cases that I have sealed in my short time on the bench in Massillon have actually, with the exception of one, have been cases that Attorney Pettit's former colleague, Attorney Maxwell, worked out with the landlord, and there was a resolution. And the landlord had no objection to, after X, Y, and Z happened, that case being sealed, meaning it was resolved. The only other case that I had that was not a legal aid involved type of case, without getting into the facts and circumstances, the first cause was dismissed, and then the tenants filed a request to seal it. So what I did was I allowed the landlord to then file a written response, gave him a 14-day period, and then took a look at the matter, did choose to seal it. Now, landlord had already filed an eviction against the people again because they still hadn't paid rent. So it helped him by not having two evictions filed, because you also have to keep in mind as well that once that eviction is filed, once that case is on the docket, even if it's dismissed, there's still that filing there. That filing doesn't go away. So if Sherry Brown sues to evict John Pettit from the house, but then they work it out later and dismiss it, if you look up either one of their names on our docket, you're still going to see that case. And it's not until maybe you do a little bit of digging to see, that maybe it was voluntarily dismissed by the plaintiff, or, it was dismissed maybe on the merits of the case. So that's still there, unfortunately, even though an eviction might not be granted. So I agree with Attorney Pettit. There may be more coming out either from the Supreme Court. I don't know if the legislature will work as fast to maybe try to come up with a mechanism, but it's a delicate situation, because you do want people to be able to not have the hindrance of finding housing down the road. But then for the landlords, they want to do their due diligence and be able to see that, no offense, Attorney Pettit, but that he's been evicted 10 times, and goes through that process. So it's a hard thing to just say that everything should be sealed or it shouldn't, because there is a lot of competing interest and valid interest in either way.
Absolutely. Great insight there. And we talked just a little bit, I think you mentioned about subsidized housing. What does happen if you lose your voucher? I mean, what is the impact of that? I don't know, maybe some of you have had experience with that. What do you tell people? What are their options?
I can jump in if others want to add to it, but I know that that's a huge problem for people, because a lot of people that get the voucher, obviously they are income limited. We do see, unfortunately, the highest demographic that gets evicted usually are single mothers, and so you think about the children and where are they going to go, that type of thing. And so it becomes very difficult. If you lose your voucher, then and you lose it for cause like non-payment of rent, because most people that we deal with do work. So we do have those that don't work, but most people that get a voucher do work. And so they pay a portion of the rent, not all of it. And then Section 8 pays the remainder. And so if they fail to pay their portion for whatever reason, then they're banned from that program. They're kicked off the program and they can't reapply for at least 3 years. And there's often waiting lists even beyond that. And so that's a huge concern, because they have to now go to pay market rent. And if they were struggling to pay rent before that on a subsidized level, they're going to struggle even more. And so we take a great interest in those cases, because sometimes their voucher is not being appropriately terminated. It's not as simple as non-payment of rent. Other issues come up. And so if there are issues, we want to make sure that the tenant's rights are protected in those cases. And so those are really important. If people are listening, if they're on Section 8, they get a termination notice, they should certainly try to call legal aid, see if we can help. We also have every Tuesday, and today's Tuesday, I think, at 4 p.m. We have a free Zoom clinic to talk to people who are worried about eviction, and they can find out that information by going to the Community Legal Aid website and looking on our events page. There's a link to the Zoom. And so if you can't get into an attorney, we can only take so many cases. You'll have the ability to at least talk with one there every Tuesday to talk about what your options are. And often there are options if you don't want to wait to the last minute, for sure.
That's good advice.
May I jump in now?
Please, Amanda. Yes, thank you.
One of the things that we're finding is, even with our assistance now, we can help with the unsubsidized portion of their rent. And so I implore people to at least reach out to us. If you only owe $25 of your rent, we're willing to pay it before you're losing your voucher or losing a place to stay. Because what we find is that if you lose your subsidized housing, most of the units, they use subsidized housing to rehouse you when you become homeless. So the first place that homeless shelters go to is metropolitan housing to rehouse people. And if you have a dent in your name, if you messed up your good name with metropolitan housing, you find yourselves really floating through homelessness, couch searching with families and kids and stuff. So we'd rather you reach out to us early to prevent that, and we'd rather pay the $25 to $50 of your rent before you lose your voucher. And that also goes for the utilities portion of that, because if they get the utilities shut off over an extended period of time, as Metropolitan finds out about it, they're in risk of losing their voucher again. So if I could tell anyone, please just reach out to us before it gets to that point.
That's great advice. There's so much help and people just don't know about it. So this is really an important conversation that we're having. Folks, we're right on track to jump into some questions that I've received ahead of time. And we're going to start with some questions from tenants, specific situations that people have run into. And I do urge anybody that's on this call, if you have questions for the panel, open up the chat box, which you can do by scrolling your mouse at the bottom of your Zoom page, and you'll find a little box that says chat. And you can type your questions in to the chat box, and we will have our panel address those at the end of the program. So don't be shy. We might get to what you're going to ask, but if we don't, somebody else might be thinking of the same question. So be brave and type it in there. Let's just jump in with, what can a tenant do if their residence is not being repaired or kept safe and sanitary? And a specific question was somebody who had 5 days with no electricity or a week of backing up sewage. What can the tenant do? Panel?
I can jump in first, and others feel free to. We deal with this issue a lot, and Ohio law does impose responsibilities on both tenants and landlords. Tenants have to keep the place clean, habitable, not cause damage. But landlords also have to keep the place habitable, keep up with repairs, and make sure that it's safe. And so, what we always tell tenants for sure is don't not pay your rent. That's the first thing that can get them into trouble, because Ohio law does not allow you to simply not pay your rent because your landlord's not making repairs. What it does allow you to do is utilize the escrow process through the court. And that is, we have a lot of information on our website, communitylegalaid.org, about how to do that, where you, in essence, give your landlord reasonable notice of what repairs need to be made. And then if the landlord doesn't do that, the next month that your rent is due, you could take your rent down to the court, the clerk's office, and deposit that rent into escrow. And then that triggers a process where the landlord wants to get that money. They have to petition the court, in essence, and the court can verify whether or not the repairs have been made. What I also would suggest to tenants, especially those in multi-unit buildings, is to consider whether or not, Ohio law does allow you to organize as a tenants union. And what we've told tenants, and we're dealing with many right now in various larger apartment complexes, that if they consider organizing, then what they can do, if one tenant says, I'm not going to pay my rent, it may not be that big of a deal to the landlord. But if the electricity has been off, or in the case I just dealt with yesterday, elevator not working for 2 months in a high rise with disabled people, if they join together and join forces, and 30 or 40 of them decide not, to utilize that escrow process, then that gets the landlord's attention. And again, if people are interested in that, we do have a program where we're trying to help tenants who want to organize, and they can reach out to legal aid, call us, and they can put you in contact with the right people to address that.
Thank you. Any
I
other?
would like to, yes, I would like to say that in Maslin, I, have a really good group of folks that I work with. And oftentimes when I get calls about problems that tenants are having with getting repairs done and all, I do work very closely with code enforcement. And we have code, they do an excellent job. They listen to the story, they talk to all the parties just like we do. And then we come to some conclusion as to how to get something done. Because your code enforcement in your cities, they can put a little more, I would say, strong arm, let's say that, to the landlords to convince them that they really do need to take care of their properties. One of the things that I ask when people call, and John already alluded to that, is if their rent is current, because your rent needs to be current before you can really have enough leverage to get something done. And so working with code enforcement, though, that has been really a lifesaver for me. And they come around and they will say, hey, Bev, this is going on. And then we'll talk and we'll put our heads together and get a lot done for our citizens.
It's great to know. Any other input on that?
I would just say real quick, that is the most important thing for tenants if they are in a situation that would be as serious as the example of 5 days without electricity or any backing up of sewer or anything that really affects the habitability of the property. They really have to go through the steps that the law affords them to get that relief. And as Attorney Pettit said, just not paying the rent isn't the answer. And unfortunately, I do see a lot of times in eviction court where it's a non-payment of rent case and the tenant comes in, shows up, which is actually a good thing because a lot of tenants don't come to the first cause hearings. And when it's their turn, they want to tell me about how horrible the property is. And it well may, I mean, I don't want to say probably is, but a lot of times it is, conditions that maybe most people wouldn't live in, but not paying your rent for a month or 2 months and either not telling your landlord, about conditions that may arise or just choosing to not pay your rent isn't going to help you no matter how horrible conditions it may be once you're already at that first cause hearing. So, rent escrow, the way that the law affords it, I mean, there are steps you have to take. And if legal aid can provide that information, whether you speak to a live attorney or through their website, or if you contact the City of Massillon Fair Housing, again, there's resources out there to help you. But again, the biggest thing is not paying rent is absolutely not the answer when there are issues with the habitability of the premises. Now, if you don't like the paint color, if it's something that's more cosmetic, that's not really appropriate for rent escrow. And if you do go those steps, that may, get figured out in the legal process of it. But if it really is a deplorable condition, there are definitely resources out there to help tenants before the eviction starts.
Thank you all. I have a weird one. This is a question that came to our reference desk at the library, and that is, can a landlord legally be placed on a tenant's renter's insurance policy if the landlord requires that? That was unfamiliar to me. Is that a thing that happens, or do you run into that?
I think I've seen it. Beverly, were you gonna chime in on with something? I've seen it. I don't see it too often, but I think landlords, they can. I don't see that there's a prohibition in Ohio law that prohibits them again from doing that. And some landlords will want sort of an indemnity clause. And so if somebody gets injured in your property, so that that person doesn't then come back and sue the landlord. And so we've seen that. There is, Ohio law does protect you against what's called unconscionable terms, and that's a standard contract term that they can't force you into a term that just doesn't make sense whatsoever. And so if the landlord is saying you have to have insurance through my brother who's the insurance agent, and the policy is exorbitant or something like that, then it may not be legal, but they could potentially put that in there as a clause.
Interesting.
Can I ask a question with that? Because what we're finding a lot of on our, especially from one particular large management group, is tenant liability insurance that they put on to be paid as part of the rent. We can't pay that portion of it. And then it's like a $36 charge per month or something. And then they'll say, well, if you don't pay that part of it, then we're going to evict anyway because we're not being made whole. And so it becomes this question that, if, if that is a part of your rent, then just roll it into it and don't tell us that you adding tenant liability insurance in it, or, or how do we do that? Because it's one of those things where we don't want to lie, but at the end of the day, is that something that they really can evict for? Because it's like, sometimes I feel like they're pulling shotgun on me to say, if you don't pay this, we're going to still evict, even if they're not. So,
Oh. That's interesting. So that's a new development, Amanda?
we're seeing a lot of it, especially with this one property management group. I'm not going to say that they're my favorite anyway, but they do, and I understand that they may have some kind of blanket insurance, but I don't know if it's a separate thing from their rent, and it's one of those things where it's on all of their things. It's tenant liability waiver, tenant liability insurance is what's written as. So I'm not sure how that goes.
I will say that I have seen, since the rental assistance is out there in the millions, right? I don't know that necessarily millions in Massillon and Canton, but really in Stark County there, it is in the millions of dollars that I've seen fraud. And so I would caution landlords and tenants who may be listening, don't, just because that money is out there, don't make up terms or things that that were not part of the original agreement, just because you think that community action can pay the money, because these are federal dollars. And so that creates a situation where we've actually referred people to the prosecutor's office, where we've seen fraud on behalf of landlords, where they altered documents, added charges that the tenant said, oh, that was never part of our original deal. And so that should go without saying. But again, sometimes when there's a lot of money out there, people get greedy and they think, all right, I'm going to take advantage of this because I didn't get paid for these months, so I'm going to make up for it here. And you don't want to do that. That'll get you in more hot water than that few extra dollars is going to be worth.
Seems ill-advised. Let's address the issue of leases, maybe in general. We've got a specific question, again, at our reference desk, as about how long before a lease renewal does a landlord have to give you an updated lease? I imagine there are rules about this. There's probably rules about if they're not going to extend the lease, do they have to notify you at a certain time? Would you like to just talk about leases?
So our perspective, I guess, is, leases too are contracts. And so you definitely want to know what you're signing. And most leases do have a clause in there for when it is up for renewal. And a lot of people get stuck with thinking that, they can just either move out at the end of the lease or that it's automatically going to renew. And some of the leases do. And often in cases where it's unclear and people continue to pay their monthly rent, it becomes a month-to-month rent situation. But some leases require you to give, a 60-day notice that you're going to terminate or something. And so you need to look at that and find out what that is. But in terms of that particular question, if I understood it right, is can there be, how long can a lease renewal, how long before a lease renewal does a landlord have to give you for an updated lease? And again, it depends. A big issue and more and I would say in the Massillon area than in Canton, or mobile home. That's a big one, especially those who own their mobile home who rent a lot. That's a huge asset that you have your mobile home that is probably not that mobile. And so, it becomes very difficult to move. And so in those instances, the law does provide an additional area of protection where the landlord generally has to have cause not to renew your lease, if you have your mobile home there. But most leases, they don't require cause. On subsidized housing, it's different. If you're in public housing, likely you're going to have cause to not have the lease renewed. And when I mean cause, there's got to be some negative reason why the landlord wouldn't do it. But in a general private landlord tenant scenario, once your lease is up, your landlord can choose not to renew that. And so it does create a tricky situation sometimes about how much you want to complain about the little things, because your landlord could choose just not to renew the lease. And it's a really favorable, I would say, landlord market right now. There's a lot of demand for rental housing. And so keep that in mind, that your landlord has the option. If your lease is up, they may have the option simply not to renew.
And Beverly, I think you were going to say something.
Yeah, just to say that those are many of the calls that I've gotten this year are, people who are just kind of at the end of their rope because they have lived perhaps in a house or in a rental apartment or whatever for a number of years. To have the landlord just, turn around and tell them like, for instance, at the beginning of September, we're not going to be renewing the lease. We're just going to go month to month, maybe for next couple of months. I'm going to begin showing the house. I'm going to sell the house because right now it's a seller's market. So a lot of these, this is what's happening, and they're getting big bucks for, much more money indeed than they would have gotten in another year, another time period. So it's an interesting situation right now. They're saying, well, what can I do? I never did anything. I've been living here for all this time. I said, but the landlord has decided he wants to quit. And that's what the term is. He wants to quit and he's going to sell the house or whatever he's going to do. Well, can he do that? Absolutely. It's his house. He can do it. And you don't have a lease agreement now. It's month to month. So yes, that gives that option.
If I could chime in real quick, Sherry,
Sure.
those are the instances that are sometimes a little bit more challenging to explain to tenants once the relationship has turned to a month-to-month tenancy. The minimum notice that a landlord has to give then is a 30-day notice. And again, if somebody has been living, somewhere for a year, 2 years, maybe even a couple months, if they collect a lot of things, especially in a time where it is hard to find housing, that's where I do sometimes have a hard time explaining to tenants that come in because they say, well, I'm paid up in rent. I don't owe them any back rent. And then that's where I do have to, I don't give legal advice because I can't give legal advice to either party, but try to explain that we're not here because you didn't pay rent. We're here because the landlord gave you a notice that you're right, Ms. Bev, that the landlord wanted to quit the relationship. And so giving that notice of termination of tenancy, sometimes people just don't understand that. And then they give that 30-day notice. They don't get out of the property. And now they have the 3-day notice or the notice to vacate with an eviction. And they're just completely confused as to why they're being evicted, even though their rent is paid up. So those are the times where it is hard as the magistrate to be like, well, I know you feel like you did everything right, but yes, the landlord essentially wants to break up with you. And that is hard for some tenants to understand. And especially right now during these times when, if you have kids and, like I said, you've lived there for an extended period of time. I mean, 30 days really isn't that long of a time period, to make all of those arrangements a lot of times.
In those kind of cases, do you grant the eviction, or is there another way to fix that situation without them actually having the eviction on their record? Sometimes people file, just to make a move, but they're being evicted, and that's a mark on their record that they can't get back.
So, and again, unfortunately, that is the hard part where I have to follow the law, because if the landlord has properly followed the law by giving the correct notices and the correct timing with the notices of the termination of tenancy, the 30-day notice to terminate tenancy. And I will just pick up here. I inherited this book from Magistrate Victor. I don't know if you can see it here, if you have one, Attorney Pettit, but we call this the Eviction Bible. You can see the tabs. This is chock full of case law. This is chock full of information for all scenarios that we can sort of envision with regard to evictions. And like I said, as long as the landlord gives the proper notice and the proper timing with the termination of tenancy, if the tenant does not vacate because a landlord has decided, again, they want to end that landlord-tenant relationship and they've done everything right, when they serve the notice to vacate, or the 3-day notice that a lot of people call it, if the tenant still doesn't get out, then I do have to follow the law and grant the writ of restitution. That's the landlord getting the physical possession back of the property. Now, again, with having a representative from your agency, Ms. Amanda, the Stark County Community Action Agency, we don't get these type of cases a lot, but I would have to say, through the moratorium, some of our landlords, not all, some of our landlords got a little crafty with trying to get around the moratorium, because the moratorium and the CDC declaration was only for non-payment of rent cases. So some of our landlords got onto that. I don't know if maybe they actually spoke to an attorney who said, hey, if you terminate their tenancy, if you bide your time and do the proper procedure, you can terminate their tenancy, and technically those cases don't fall under the moratorium. So with having someone from your agency there, Miss Amanda, for those tenants who have fallen into that, I know your representatives have, I think, spoken to some of them to help, like you said, offer some assistance moving forward, even though they may be paid up on their rent, but maybe they still are affected, by COVID, to try to help them. I know I sort of answered a couple different things there, but yes, if the proper procedure is followed by the landlord, I have to follow the law and grant the eviction in that instance.
We're going to, I should just jump in and say, I think I know the answer to this one based on what you just said, being that you have a contract between a landlord and tenant, but I assume the landlord can raise the rent to whatever they want the rent to be. That was another question. Is that the case? The question is, can the rent just go up to however much the landlord wants with a lease renewal or when you get a new lease? So does that sound right?
Yeah, I think generally speaking, that is true upon proper notice. And again, if you have a lease and your lease is you're still in that lease, they can't raise the rent during the term of that lease. They have to wait till the end of that lease, give you proper notice and so forth. The only exception to that is some landlords that receive Section 8, that participate in the Section 8 program, or public housing landlords, they cannot raise the rent in some circumstances. They have to go through the process. And we have seen some landlords who try to circumvent that by adding additional fees is a way to get more money out of Section 8 people. And that's not generally permitted. But, in a private landlord context, yeah. The only time I see where we run into at legal aid, sometimes we see landlords charging unconscionable late fees. And so those things sometimes can have a cap on them. And, unconscionable is kind of, that depends. And that's a question that may get to Magistrate Scazza to determine what that is. And we may argue that it is, and the landlord may argue it's not. But as a rule of thumb, $50 a month, we've seen that as a late fee type of thing that we probably wouldn't think is unreasonable or unconscionable. But I've seen other times where it's like $5 a day or something like that, or it goes up incrementally after 10 days, and so sometimes on those situations you may have a legal basis to challenge that.
So Well, we have a question in chat and we had another question at the reference desk talking about security deposits. So Benita, Renetta, I'm sorry if I'm mispronouncing, but is there anything that can be done if a landlord keeps a security deposit or a portion of it for no reason? And that's a great question. And we had a similar question about what if you don't get your security deposit back for whatever reason, and they don't notify you of what that reason is. So somebody like to address the whole security deposit issue?
Can I just start with something? I talk to people in regards to their security deposit, and what I do encourage people to do, and I ask them all the time, do you take pictures? Because what happens sometimes, and it's not all the time, I'm sure, but what happens sometimes when they move out, I've received reports that there were things that were done to the house. They left the house in pretty decent shape, and then they get charged for things with cabinets falling off or something else happening that was not happening before. And so I try to encourage people when they're calling about anything to please take pictures, put dates on them. You know, you do everything with your phone. Your phone has a good way of logging what things look like. You move out and your landlord does not want to do a walkthrough with you. That means you need to have pictures to show exactly how you left the apartment or how you left the house, whatever it is. And so you have yours, because my word against your word, it's all it is, are words. But pictures, you know, and other things, documents with signed documents with dates make a big difference. And so therefore, I try to encourage them to definitely take pictures and make sure they have proof of how they left the apartment or how they left the house. And so there would be no reason then for your landlord to keep your security deposit if there's no definite, not natural, normal, wear and tear, but there's no holes in the walls, doors are not falling off, all kinds of things like that. Because a landlord is supposed to provide you a list of everything that he had to do that was beyond normal wear and tear, and give you those and make sure that he has the receipts as well. That's what I've always, shared and knew in regards to that. So, yeah.
Sounds like good advice and good protection for the landlord as well, who I've heard of one landlord who will do a walkthrough with a video camera and zoom in onto the date of a newspaper to prove the exact date they were, seeing what they were seeing. Sounds like as well. Benita follows up her question with a reason with the landlord, they're completely unreasonable and needs help. Would that be something that community legal aid, John, should be contacted?
Yeah. So our website, we also have materials about getting your security deposit back. And so I would encourage people to go to that. We have a whole section on that. That book that Sherry, I think you showed, Your Rights as a Renter, has a whole spot on that. And again, people could contact Community Legal Aid. We'd be happy to send you that. There's actually a virtual book like that on our webpage too, that you can get to, where we have all of that there. But yeah, and generally, and a great recommendation there from Ms. Lewis. But I would add to that to say that generally what we see when we talk to people with this, make sure that you provide your landlord with a forwarding address, an address where they can send the check, because that's an automatic out to the landlord if they don't know where you are. That being said, they have generally 30 days to give you an accounting and give you back the amount of money versus their accounting for damages beyond normal wear and tear and any unpaid rent and what you owe. And if they don't do that, the law allows you to go back in and get double the amount that's owed. And so it's a process to penalize landlords who wrongfully keep that money. But definitely, yeah, protect yourself, you should do a video when you first move into place. Take a look at what it looks like and then have one at the end so if you can contest the charges, if the landlord's trying to get too much money for what a repair may be, that's something that you can, again, try to work out first before you go into court. But, it is an issue that you're entitled to that money back in a timely manner.
Let's jump into maybe some questions from the landlord's perspective. And we're going to get to the emotional support animals in just a minute. I see that's in our chat box, but it's also on our outline. That's a big one. But before that, let's talk about, is there any mediation available when you want to solve problems without evicting? And Magistrate and I were talking about that not very long ago because there's a new toolkit about that. So do you want to start with that, Andrea?
Yes, and the toolkit that the Supreme Court of Ohio put out, as I indicated to you, Sherry, is chock full of information. I believe it's over 100 pages or so, a lot of sample forms in there. I can tell you our court has not adopted any type of formal mediation with regard to evictions. And I will say, at least with the first cause of action, we do have mediator at our court. He is an attorney that handles mediation with regard to our civil cases. And if there is a second cause of action or the money part of the lawsuit that we talked about a little while ago, if the tenant files an answer for the second cause of action and appears, that case will be sent to our mediator to try and resolve those issues before any other hearings, formal hearings take place with regard to the money part of the lawsuit. But at this point, we haven't adopted any type of formal mediation process with regard to the first causes of action, short of me saying to the landlord and tenant, if you want to go take a few minutes out in the hallway, feel free. With the relief that is out there, whether it be through Stark County Community Action or Job and Family Services, I again, within reason, am liberally granting continuances when both parties are on board and actively seeking to get those relief funds. So no formal mediation. And again, that's once the eviction has been filed. We also don't have any informal mediation set up within the court that I think with regard to the question to solve problems without an eviction. We don't have that set up at our court. And I don't think there's any talk to try and do that before the eviction is actually filed. But like I said, once that eviction is filed, we are trying to take steps to try and mediate it, not in a formal setting. But if a landlord and tenant requested to go in front of our mediator, I wouldn't have any problem with sending them to mediation. It's just sometimes with the quick nature that that our eviction hearings are just that nature of quick hearings, it just doesn't sometimes lend itself to mediation within our court. But at this juncture, I'm at the point where if it keeps people in their homes, if it gets landlords, the money that they're owed, and all parties are in agreement, I'm for whatever we can do to resolve the case.
Thank you. Well, let's talk about the animals. And I know that I saw a question about that in our chat, and that was on our outline as well. What are rules regarding emotional support animals? Can you address the whole service animal and emotional support animal? And Beverly, maybe you want to start with this one and we can bounce it around.
All right, thank you. The one thing that we need to understand is that an emotional support animal and a service animal are not one and the same. Emotional support, they provide the comfort sometimes that people need. they calm them down. They do a lot of things, but a service dog is a dog that has been trained for a specific task or a purpose in dealing with someone that might be blind, might have, some other serious conditions that the dog has been trained for. And so we need to understand that an emotional support animal is any animal that provides emotional support, alleviating one or more symptoms or effects of a person's disability. Emotional support animals provide companionship, relieve loneliness, and sometimes help with depression, anxiety, and certain phobias, but do not have the special training to perform tasks that assist people with disabilities. Okay, so we need to understand that. Normally, you'll get people calling and saying, my landlord does not want me to have my emotional support animal, but I have a doctor's a letter that allows me to do so. And rightly so, they get the letters and they're able to do that, but they don't have the serious or the paperwork that a service animal would have, and have that service animal has a lot more that he or she can do as far as, being able to help a person. Individual with a disability may use and interact with working animals for a variety of reasons, but only dogs who have received specialized training to perform a specific task or tasks for an individual with a disability are considered service animals. This is the key difference between a service animal and all other types of working animals, including therapy, comfort animals, and emotional support animals.
So for a landlord's perspective, are they allowed to say, I don't accept emotional support animals, or is that, cannot say that?
No, I guess, and others can chime in, but yeah, one of the tricky things, we deal with this a lot, especially with people that have mental health issues that they're dealing with, and they need their dog or another animal. The most important thing is get a letter from your doctor, your counselor, your medical professional saying that this animal is needed for your emotional support, and then share that information with your landlord, because that dog or cat, whatever it may be, no longer becomes a pet, and so they're not part of the pet requirement. Your landlord can say, I don't allow pets, but this is not a pet now. This is now an emotional support animal. And so if your landlord tries to prohibit you from doing that, that is a fair housing issue, discrimination based on your disability. However, that doesn't give you free reign, right? So we've had cases where, you have to take care of that animal. You can't let the animal, destroy the place or desecrate, common areas or things like that. And so you're responsible to make sure, that animal is properly taken care of. And if you don't do that, then you can potentially be evicted for not taking care of that situation. But it creates a whole a whole Pandora's box of issues that sometimes come up. And it's the biggest thing I would say there, and that may be a grounds for mediation or having somebody discuss that, is have some discussion with your landlord. Don't go into it with the standpoint, if you're a tenant, by saying, well, my landlord has no business knowing why or whatever. I mean, share the information. Your medical history is private. You don't have to share your disability, but you need to probably share that you have the medical documentation that allows you to have this animal. Don't go in difficult with your landlord, but on the landlord side too, you can't be you can't have a 100% policy saying, I don't allow animals no matter what, because if there are circumstances where somebody has a disability, then they have a right to do that, so long as they reasonably control that animal.
Mhm.
Mhm. Go ahead. Well, I think that reasonably controlled thing is important. We know that from just having a public building here at the library and, you know, we must let animals in, but we can't, they don't have to be barking or biting the other library patrons, you know, you can set some parameters about how they behave. So that's
right.
an interesting idea. We had another question on chat about, for a couple new landlords, it sounds like, what's the best way to screen applicants before choosing a renter? And I think that I heard something at the very beginning about doing due diligence. What does that involve? How should you be looking for people?
You know, they have, they do have some guidelines out there that you can look, you know, and I would suggest that any landlord to look at the information that's out there that tells you how to put together an application that answers the questions that you need to have answered. And make sure that's the application you use for everybody though. So that it's not, you know, so I'll take this one and so this person's coming in, oh, they don't look quite right. So I'll give them this one and I'll give another one another. But really, there are good applications out there that will allow you to get much of the information. If there are places on the application that an individual doesn't want to sign or fill out and give you the right to look at a credit report or to just, you know, find out some other information that's pertinent to them being able to be a good tenant in your property, then those are kind of red flags. There should be no spaces or anything that's left out. Everything, and you know, if you have the right, you know, application and you have everything on it that you need to have, then a person who is, you know, coming with the right motive in mind and everything will not mind filling out that application. So that helps with your screening right there. You know, we can't look into a person's heart and see who they are or, you know, just determine, just, you know, think we know who they are because you can't really judge a book by its cover. But if you get a lot of the basic information, then you'll be able to select from the list that you have or the applications you have, perhaps a very good tenant and be able to work with them.
That's great advice. And I will say, speaking of books and covers, the Landlord's legal guide that I have in my hand, it sounds like you wrote this one. Because the first chapter is screening tenants, your most important decision, and talks about applications, checking references, and all those things available for checkout from the public library. So
I don't know if Ms. Lewis has programs for landlord. I see one of the related questions there was about, is there advice or something to show landlords the ropes of being the landlord? But I know that an agency that does cover our area, they're out of Akron, but a nonprofit called the Fair Housing Contact Service provides a lot of free training for both landlords and tenants. And so I would encourage people to look at that. And you could find their website. I can try to put it in the chat, but it's a Fair Housing Contact Service. But they often provide trainings to landlords about, you know, not getting yourself into trouble, right? Not doing the wrong thing. And they're really good at it.
If I can add too, Sherry, you know, I understand that a lot of landlords get into this business either, you know, as maybe one property, investment property, or, you know, the big multi-unit apartment complexes. But, you know, short of a landlord or the entity being an LLC, if it's an LLC, and this is a whole nother topic that I could go on and on about, if it's an LLC, you have to have an attorney. You have to have an attorney when you file the complaint. You have to have an attorney representing that entity in court. And again, people are not very happy with me when I dismiss their complaints in court because they're an LLC, because they're like, well, I am the LLC. And I'm like, well, under the law, that's a completely separate entity that you're enjoying the protections of. So you have to have an attorney. But what I would say from my position is, landlords, I get it. It's your property. It's your business interest. You have your interest, but again, you're talking about evicting someone from their home. So, I tell landlords all the time that just because a tenant may not be here to contest what you're saying, you still have to be able to prove your case. You still have to be able to prove, what the terms of the lease are. And I get landlords coming in court sometimes more than I wish that, they file the complaint, they'll attach the notice to vacate. And when I ask them to testify all that, they're like, well, you have it right there. And I'm like, no. As a landlord, you have rights, but you also have responsibilities that you have to be able to come into court and testify to. You have to keep records of what your tenants are paying you. And again, just because the majority of tenants may not show up into court, I still have to hear just, the basic information to evict these people from their homes. So I always tell landlords, I know attorneys can be expensive, but go get the legal advice that you really need as a landlord to make sure that you are complying with all of the responsibilities that come along with being a landlord under the law. It's confusing. Sometimes the law still confuses me. I should say sometimes. It confuses me. That's why we have these books to help us. But, and I get, like I said, attorneys are expensive and landlords just want to do this. And there's so many resources out there to help landlords. But a lot of times I just really wish landlords would get the advice and get the help from an attorney so that I don't have to dismiss their actions in court, so that they have that help throughout. In the same with tenants. On that notice to vacate, the 3-day notice, if the landlord is complying with the statute, there should be a big conspicuous box in all caps that says to the effect of, you are being evicted. If you have any questions, seek legal counsel immediately. And that's language that's supposed to be on every 3-day notice. And I wish more tenants, heeded that advice early on, rather than waiting till they come in for their first cause and saying, well, I think I want an attorney now. Cause I'm like, again, I wish more people would take advantage of the resources that are out there. And like I said, maybe seek legal advice before it's at the point where it's in the court.
Thank you. And LaKendra, it sounds like maybe, and the library would be interested in supporting this. And Miranda does adult programming for the library, and maybe some additional programming for new landlords, or we can schedule something like that for additional resources. I think would be a very good service to the community. And it is something that we don't talk as much about, because you're writing there. A lot of people just end up in it with one building and no training whatsoever. There's just so much to know. Let me just scroll down through these chat. I think we've pretty much touched on all of the chat questions. We put links there for legal aid. We put a link there. There's fair housing. Thank you, John, for adding those. And you probably have seen in chat, if you're looking in there, that Amanda Stewart had to pop off this call early, and she gave all of her contact information for Stark County Community Action Agency for all the services they provide. So please check her contact information, and I'll stay on the call for a little bit after we end here. But I just thought we'd close down. I'll let the 3 of our panelists that remain just have some closing remarks. If there's anything you thought we should talk about, we didn't. This is the Miss America question. So let's start with Beverly. Do you have any other advice for the folks on the call?
Well, I do want everyone to know that there is a nice pamphlet that's put out by Fair Housing Center for Rights and Research. And let's see, I don't know how I can get this up where you can see it.
Yeah.
Can you see it good?
Yeah, I can see it real well.
Oh, all right. And it is for people with criminal history. There's a lot in it that just gives you general information. and then gives you the sources and kind of research to get more information and knowing how to circumvent the whole problem of having a criminal record, and 9 times out of 10 checking that box on your application, and your application is done because your landlord doesn't want anything to do with you, but that's really against your rights. And so therefore you need to investigate that. And when you know your rights, you can have rights much better. Okay, so I wanted to share that, and I just wanted to take this opportunity to say I'm Bev Lewis. I'm downtown in the city of Massillon. I'm in the administration building right across from the Lincoln Theater. And the numbers go on the website. You can get all the information you need to get in touch with me. I'm open to your call and whatever, to just get something done for the citizens of Massillon.
Thank you, Ms. Lewis. This is
Thank
appreciated your time. Attorney Pettit, you have some closing remarks?
Sure, just thank you. Thank you all for your interest in this. I appreciate it. It's a great panel. It's great to hear from Fair Housing and from the court and you know, from the service providers. So I appreciate the interest in the topic.
Thank you so much. And Magistrate?
Okay, sorry, trying to unmute myself. No, this has been great. I think we all could have went on. At first, I thought an hour and a half. How are we gonna fill up that time? But we really, at least I could probably go on. What I would just, my close, I would say, to landlords, to tenants, probably more so, don't wait till the last minute. Don't wait till you are before me to try to take action. I know it can be overwhelming. I know, that a lot of people just deal with things differently, and especially during these very trying times for everybody. A lot of times it is just easier to just ignore uncomfortable things, and especially if you are facing eviction, but don't wait. There's so many resources out there. Don't wait till the last minute. But if you are coming into court, I would just say, please bring with you whatever evidence you have that you want me to see. I hear all the time people saying, well, I can get this for you, or you can call someone, or I can do this. Have it with you that day, especially if you are paying rent with cash, which I really wouldn't advise, but if you are paying rent with cash, bring receipts, get receipts from your landlord, vice versa with the landlord, have your documentation there. Taking pictures, taking video with phones are great, but I'm pretty sure you don't want me to admit your phone into evidence. So if you can print out pictures, that would be great as well. So I guess my lasting thing would be bring whatever evidence you want me to consider at court if we have to get to that point. But thank you for having us, Sherry.
Thank you. Thank you all so much. And we consider you some of our absolute best resources, better than books on the shelf. And we really appreciate the time you spent with all of us this evening. Everybody, you're welcome to get a hold of me at the library. It's, well, you know where I am. And you can Google the library, you can send me an email or call me anytime. I can connect you with any of our panelists. And I'd just like to close out the evening by thanking everyone again for being here. LaKendra, I will definitely look into thinking about putting together some additional training for new landlords. I think that would be a great service. So thanks for your great ideas and great questions, and have a wonderful evening, everyone.
Thank you.
Thank you.
Thank you. Thanks, John. Bye, Angela. Hi, Rick Cicconelli. Bye. I knew some of these folks on this call, so that's exciting. I just didn't get to see their face. Look at that cute dog. Cute dog. All right, so have we stopped recording?
I'm going to hit stop right now.
Okay.